Good afternoon, everyone. Welcome to this special recording of Fear and Greed at Clio's Innovate Legal 2025 event. We're opening up today's discussion with some breaking news, very exciting. Clio has today launched research that reveals an alarming trend in the Australian legal sector, a situation we're calling the data lock-in crisis. On our panel today, we have Clio CEO and founder, Jack Newton, and Caralee Fontenele, founder and director at Scalable Law. Let's jump into it. The data, Jack. 1 in 3 Australian law firms face an average cost of $25,000 and month-long delays just to access their own data when leaving a vendor, which really surprised me that could actually be the truth of the matter. What's the true scale of this data lock-in crisis? Why is it so prevalent right now in legal tech?
Well, as the data highlights, this isn't an isolated issue. It's a pervasive problem. And especially in the context of legal data, this is ultimately data that belongs to the end client who is having legal services delivered to them. And so any vendor trying to create friction around exporting that data is ultimately undermining the client's rights to that data. And obviously the law firm's flexibility in choosing the system that they choose to host that data in as well. So we at Clio have a philosophy and approach where data portability is fundamental, and we believe that a law firm should be able to export data out of Clio at free will and in open formats that can be imported into other systems at a time of their choosing. And the way you want to create recurring clients that choose to renew with you every month is by delivering a terrific product and a terrific service, not by creating friction around exporting your data and trying to get data out of a system. And that frankly is the way I think every software provider should operate, because creating data lock-in just creates a ton of negative downstream impacts, both for law firms and for clients.
How did we arrive here? Why are we in this situation now?
Well, I think it's frankly the result of some companies taking a very short-term orientation and perspective on how they approach business. And the right long-term approach, I think, for the industry is to create data portability and to have a common set of standards for data portability that allows data to freely interchange between systems. And again, law firms' requirements may change from time to time. They may have their practice evolve or change in a way that would make one system a better choice for them today that maybe wasn't the right choice for them 3 or 4 years ago.
Yeah.
And as a software provider, I think ultimately it's incumbent on you to create that flexibility for your clients to choose whatever system they want to use. And that will go both ways, by the way. You'll have people that end up choosing your system as the destination of choice for their data and will bring their data to your system. And ultimately, I think it's better for the industry as a whole to be cooperative and to offer free and easy data exchange between products and as much data portability as possible, as opposed to, like I said at the beginning, a more short-term orientation that, again, is maybe maximizing in the short term, which is saying, we're going to lock your data in, we're going to create a ton of friction to get your data out of our platform. But the negative downstream effects that has and the amount of trust it undermines in software vendors more broadly, I think, pays a very negative dividend over the long term.
Caralee, you've lived this. Is that correct? Maybe you can take us back to that moment when you discovered that those assets that you own weren't yours, or they were yours, but you couldn't get to them.
Yes, so we were with the same company since 2009. I didn't know anyone at the company except they would call at renewal about a month out to make sure that we were locked in for another 3 years. And over time, that started to wear pretty thin with me. And around 2016, I thought I've got to get into a different practice management software. But for a small law firm, there's a fear about what the hassle is going to be, how much that cost is going to be. And of course, there's murmurings in the industry, and we know that this is what happens, and it makes it super expensive for a small to medium-sized firm to actually make the change. And I didn't see that there was a vendor in the market that was particularly any better or different until I went to ClioCon in 2022 in Nashville, and I met the team at Clio, and Clio at the time wasn't properly down in Australia yet, but I was very excited to learn that it was coming to Australia and that they weren't locking you in. Which made a huge difference, because what it means is that, as a scaling firm, you might have a team of 15, that might drop down to a team of 13, and then you've got 2 licenses sitting there, for example. So it's not just that you're locked into their product, you're actually locked into licenses as well. And it makes it really unscalable. They're not prepared to work with you as your firm grows, and because firms don't grow on a straight up trajectory like we hope they would. They grow in ebbs and flows. So,
were you aware of it the whole time that you were with this other firm, that it was something you should have done something about? But whether you were running the business, whether you were growing the business, sometimes it's just too hard.
Yeah, I don't think, in 2009, practice management softwares have evolved a lot since then, but I don't think it was something we were aware when we first signed up with them, but it certainly became, you became aware that your data was going to be very difficult to extract or very expensive to extract. And just to be clear, it's not the data. You're allowed to take the data. You're not allowed to take the documents. So that's what became very difficult to get out. And as a law firm, you can't. You have the option of leaving the documents in that practice management software, and paying the fee for the next 7 years until your documents expire. But then you've got 2 systems, and I know firms that are doing that, and it's just very awkward. Or you can pay them a whole lot of money to get your data. There are other options, but it's risky and difficult.
A familiar story, Jack?
Yeah, we've surveyed over 1,000 lawyers on this specific issue, and 71% of the lawyers we surveyed had experienced this kind of data hostage situation. And that's just a crazy statistic in my mind. There's a clear supermajority of lawyers that have experienced this in some way, shape, or form. We see this really as a crisis, and it's one that is creating an unreasonable amount of headache and friction for law firms and for clients alike. And again, I think it would be one thing if you said this is an isolated issue that impacts a very small minority of law firms or small minority of lawyers. Or if there's a very small minority of software providers that were engaging in these pretty clear customer hostile tactics, but it's common practice. And I think what is truly insane to me is that it's become almost normalized when I do think it's a fundamental right of lawyers and law firms to have access to this data on an unfettered basis, and to have the right to be able to port that data to an alternative provider if that's the choice they make.
I'm sure 100% of the lawyers in this room understand this fully, but in the broad world out there, do all lawyers understand what you're talking about, data portability?
Well, again, in this survey, we saw that there's actually pretty good understanding of what data portability means. 84% of the lawyers we surveyed understood the concept of data portability and what that meant for their software applications. But what was very interesting, and I think, again, there's a lack of transparency around this on software providers' parts. Only 52% of the lawyers we surveyed were able to actually identify whether their current software provider would enable that data portability should they need it. And again, it's something that very few software providers advertise or have in their support documents or have outlined in any kind of frequently asked questions document. It's something that you might have to ask very specifically what the export and data portability capabilities are. And then even then you need to make sure that you can actually test that data portability, because again, you might just have a salesperson telling you what you want to hear and say, oh, of course you can export your data. But as I'm sure you found out, you often don't truly find out how portable that data is until you get down to the brass tacks of actually having to undertake that data export. And we've even seen situations where the data starts out being portable, the provider notices that the data is being exported, and then actively injects itself to limit the data export rate or to otherwise create barriers around a data export. It's really almost a very deliberate effort to keep the data captive and in turn to keep the customer captive.
Then if everything I've heard today, if I'm a law firm and I want to innovate and I want to change with the times, then I'm running into a roadblock right up front.
That's right. There's structural roadblocks and very deliberate efforts to create friction around customer movement and to essentially entrap customers in their current solution. And this is such a stark problem that there have been class action lawsuits filed against some of these providers in a variety of different jurisdictions around both abusive contract practices as well as overly restrictive data portability capabilities.
Caralee, so what did you do? Tell us the rest of the story.
Well, the first thing that we did was I made sure that I put in my diary when my license was going to be expiring so that I knew that we were coming up to that time. And so 12 months out, we started planning, which I think is so important, and just a message for anyone who wants to move to a Clio. You want to make sure that you've got a really long runway. Don't leave it till like 2 months out. It's just not enough time. Our firm had 15 licenses, and we got a migration specialist to help us, David from New Law. He's here today. You definitely need that assistance if you have got as much data and documents as we had. So we got ourselves set up really nicely nearly a year out. And then we did the migration of the basic data, which is the names, like how you open a matter, basically, all of that kind of thing. That was no issue. And then we started migrating out some of the documents and over a weekend, so you need to do it while you're not in practice. And then our whole system would shut down, and we weren't allowed to access some of our licenses. So we'd have to make a phone call to get our system turned back on so that we can practice law on Monday. And they would express that, we weren't to be extracting our documents, more than 99 documents at a time. My firm had over 500,000 documents to extract. So it was a very, very challenging, and we tried that again and again and again and again and again. We would have to make that phone call to try and get our license back on track with them so that we could keep practicing while we were trying to do the migration. It got to a point that I looked at other options. There are other options. You can extract 99 documents at a time. I calculated that and worked out how long that would physically take to do, and it was actually ridiculous. And I was so annoyed at what was happening that I thought I would rather pay someone somewhere to do that for me than to pay them to do a 5-minute job. And I did look at that, but after calculating it, it just wasn't practical, and it also left us at risk, because what if in us doing that 100 documents at a time or 99 documents at a time, we lost some documents or something like that, because that could easily happen because you're not doing it cleanly. Mm-hmm. But we didn't have the opportunity to do that cleanly at all. And so with very gritted teeth, I signed a check or paid the bill to get the documents extracted. Our bill was not $25,000, it was about $16,000. But yeah, just really quite mad about it.
So when you went to Clio, or you go to any new legal tech vendor, what are the questions you're asking now then?
Oh, absolutely, and not just with like your legal tech, but also things like running your Google Ads. I've been called out on things like that as well. Make sure it's yours and that you have the ability to do with it what you need to in order to run your firm. And yeah, so that was definitely something massively appealing about Clio. Is that's made really clear, as well as the fact that you can, you can leave any time. You're not held hostage. But it's such a great product, and the company itself has such an awesome culture in their teams, and also as customers, that you're not wanting to move on from them anyway.
So, Jack, bringing this together in terms of the industry as a whole, what's the sort of standard that it should have going forward?
Well, I think it sounds so straightforward. It should be obvious, but it's not, unfortunately. But I think it's really clear that the fundamental data ownership lies with the customer, not the software provider. And that is your data, and you have the right to that data on an unfettered, unrestricted, ungoverned basis. Meaning that if you want to extract all of that data to do whatever you want with it, that should be a fundamental right. And by the way, we talked about this in the context of this conversation around accessing the data in the context of needing it for data portability to another software provider. But there are a wide variety of other use cases that could make sense for why you would want to do that. You may want to export the data to train your own AI model on that data. You may want to do some sophisticated modeling or reporting on that data. You may want to use that data in a wide variety of contexts, that extracting it in an open standard format that can be parsed and interpreted by a wide variety of other software products, again, is something I think obviously should be the right of the law firm that owns that data. Especially in the context of legal data, where again, it's not so much the law firm that owns that data, but at the end of the day, the client is the rightful owner of that data, and the law firm and the software provider in turn are just stewards of that data on behalf of the client, and have fiduciary duties to that client to be able to produce that data for some fixed amount of time, often on the order of 7 years. So that data portability is absolutely essential. I would like to see the emergence of a standard set of document formats that are used for data portability, and a standard set of expectations, and maybe even a designation that a software provider could show to indicate they subscribe to a certain set of standards relating to data portability. Because again, this transparency around how portable your data is really tricky. And the best you can do, short of a set of standards guaranteeing access to that data, is to actually test the data export capabilities. So this is almost like entering a prenup with your software provider of choice, where I think part of that agreement needs to be, you want either contractual guarantees or technical guarantees that you can export your data. And then you want, as part of the sign-up process, again, ask for a demonstration of how you can export your data and get it out of that system. And again, I think that's where you'll be able to separate the providers who truly are committed to data portability from those that are not, because the ones that are not will tell you, well, we'll cross that bridge when we come to it, and we'll get you your data, but it might be a process. Versus a company that should just be able to point you to a data export page on their website that allows you to export your data on demand. At Clio, we even have what we call a data escrow service, where our customers can point Clio to an Amazon S3 bucket, and every night we will replicate their data to that S3 bucket to guarantee them of an ongoing backup of their data in a set of open data formats that, again, they can use for any purpose they want. Now, short of companies just self-governing on this front, there are some promising standards and expectations and laws being issued in a number of jurisdictions. There's a set of new regulations emerging in the EU that will demand data portability of software providers, and in the space of 30 days, you'll be required to produce a high fidelity export of client data by 2027. So above and beyond encouraging this good behavior from software providers, to the extent you can influence Australian legislation, I think there's a call to action for the people in this room and the people listening to this podcast to think about how can we influence a regulatory landscape that will mandate this. Because again, I think this is a set of fundamental rights that we all, as consumers of these digital services, should have to access our own data in a set of open formats that allow us to back up that data, to leverage that data for whatever purpose we want, or to leverage that data into a new platform of our choice.
That's not just a legal issue either, though, is it?
No. I think it's exacerbated in the legal industry, and in particular in Australia. When we look at these statistics around the majority of people that have experienced friction around this, I think we've got, unfortunately, a marketplace here where these customer hostile practices are the norm rather than the exception. But I think this applies to our digital footprint overall. We should have the right to access our data on whichever platform we happen to be utilizing, and our legal software applications are just a subset of those applications that we should have that expectation of.
Time is up. Jack, Caralee, thank you very much for sharing such a critical and unnerving look at the state of data custodianship in Australian legal tech. I think it's probably a wake-up call for the entire industry, I dare say. Thank you, Jack and Caralee, for your this afternoon.